EFF leader Julius Malema and co-accused Mbuyiseni Ndlozi will learn their fate in the Randburg Magistrate's court regarding a common assault case dating back to 2018. The pair brought a Section 174 discharge application before the lower court in May. They're facing common assault charges for the alleged assault of Lieutenant-Colonel Johannes Venter during the burial of Winnie Madikizela-Mandela on the 14th of April in 2018. Let's take it there live.
Possible factual situations that may or may not arise. Former J held that it is unwise to attempt to banish issues of credibility in the assessment of issues in terms of Section 174 to confine judicial discretion to musts or must nots. 20. It is submitted that the present legal position regarding applications in terms of Section 174 may be summarized as follows. Sub 1. An accused person, whether or not he is represented, is entitled to be discharged at the close of the case for the prosecution if there is no possibility of a conviction other than if he enters the witness box and incriminates himself. Sub 2. Deciding whether an accused person is entitled to be discharged at the close of the state's case, the court may properly take into account the credibility of the state witnesses. Sub 3. Where the evidence of the state witnesses implicating the accused is of such poor quality that cannot be safely relied upon, and there is accordingly no credible evidence on record upon which a court acting carefully may convict, an application for discharge should be granted. 21. In order to apply this test, regard must be had to the allegations levelled against the accused in the charge sheet. 22. The accused are arraigned on one count of common assault, where it is alleged that upon or about 14 April 2018, and at or near Fourways Memorial Park in the district of Johannesburg North, they did unlawfully and intentionally assault Johannes Venter by pushing him. 23. Both of the accused pleaded not guilty. The basis upon which they did so was one of justification. Both accused believed that they were entitled to enter the cemetery for burial ceremony, that the obstruction of them was illegal and unjustified. In the circumstances, they lacked mens rea because they believed at the very least that they're entitled to enter the cemetery for a burial. Additionally, there was a political agenda. They both reached out to the complainant by a process of Ubuntu that was rejected by AfriForum. There was a political agenda between AfriForum and the EFF. 24. The state led the evidence of 2 eyewitnesses, Colonel Fenty and Staff Sergeant Mapisa, and 4 witnesses who dealt with the evidential material and chain of custody relating thereto, Mr. Klingbeil, Colonel Bronkhorst, Colonel Sianejo, and Warrant Officer Smith, and showed a video depicting the event. 25. We respectfully submit that this application will demonstrate that the accused is entitled to a discharge at the close of the state's case in that. Sub 1. The state has not led any evidence to show that the accused were not entitled to enter the cemetery to participate in the burial ceremony. Sub 2. The evidence led does not show that the accused had the intention to assault the complainant. Sub 3. The accused is not required to give evidence to supplement the state's case. Subheading the evidence. 26. The first witness called by the state was the complainant, Colonel Johannes Venter, testified inter alia as follows. Sub 1. He was based at the South African Police Service Presidential Protection Service, head office in Pretoria. Sub 2. He had 36 years service, of which 6 years were in that unit. Sub 3. He was a planning officer responsible for the protection of the President, the Deputy President, heads of state, former heads of state, and former heads of state of the Republic. Sub 4. On 14 April 2018, at approximately 15:40, he had been on duty at Fourways Memorial Cemetery in uniform at the main entrance with 2 other women. Sub 5. The hearse had arrived, followed by the President, the Deputy President, heads of state, and previous heads of state. Thereafter, a Mercedes-Benz Vito came to the gate. Sub 6. He did not see any visible vehicle permit. Sub 7. Normally the permit is placed on the left-hand side of the vehicle on the window. Sub 8. Such a vehicle permit means it gives you permission to enter the said premises. Sub 9. He stopped the vehicle and spoke to the driver, who informed him that the leader of the EFF, namely Mr. Malema, accused 1, was inside the vehicle. He then saw Mr. Malema inside the vehicle. He greeted him and informed him that the vehicle cannot enter. They had to walk inside. Sub 10. Mr. Malema informed him that they would not walk inside, they will drive in. Sub 11. He then said that he will first get permission from the Venue Operations Center, or VOC. He then tried to contact the VOC. Sub 12. He was then pushed from the right-hand side but could not say who had pushed him. Sub 13, he then saw Mr. Malema jumping out of the vehicle. Sub 14, Mr. Malema said, "No white man will stop me." He was then pushed a second time from his back but did not see who it was. Sub 15. He then moved back to the front part of the vehicle where he was pushed by both of the accused. Sub 16. The second time he was pushed so hard that he lost his balance and fell against the guardhouse. Sub 17. At that stage, General Zulu came closer to him and told him, "Leave, leave." Sub 18. At some stage, the accused got back into the vehicle and it then drove into the cemetery. He had no idea who had given it permission to do so, as neither he nor General Zulu had given such permission. Sub 19. General Zulu is his senior and works at a different department of the SAPS. Sub 20. The vehicle was stopped because the whole convoy was already inside the premises. It came afterwards and had no escort. Sub 21. He had been instructed by Lieutenant-Colonel Johannes Venter that only the immediate family and the president could enter the cemetery. The rest of the people would remain at the stadium where big screens had been erected to televise the funeral proceedings. Sub 22. He then utilized the map to indicate where the allocated parking was in the VOC. Sub 23. The accused had personal permits around their necks, but he had not seen a visible permit on the vehicle. Even if he had seen such a visible permit, he would have stopped the vehicle because it was not part of the convoy. Sub 24. The cars which had permits to enter the cemetery in the convoy of the Mandela family, the President of the Republic of South Africa, followed by the Deputy President, followed by heads of state. Sub 25. He was then shown video footage. The dispute concerning the video footage of the incident, authenticity and completeness thereof was placed on record. Paragraph 27. The following was elicited from him during cross-examination. Sub 1. He had been told over the radio when the convoy left the stadium but was unaware of the time because he did not look at his watch. Sub 2. He described the arrival as depicted on the video as not being haphazard in his view. It was orderly. Sub 3. The funeral program which was then shown to him had not previously been shared with him. This was subsequently admitted as Exhibit A. Sub 4. Item 17 on the funeral program was a tribute to the deceased, Mrs. Winnie Madikizela-Mandela. Sub 5. Despite the official program indicating that accused 1, Mr. Julius Malema, was instrumental in those proceedings, he had never received at any stage such a program. Sub 6. The Mercedes vehicle that the accused were in was accredited, but he maintained that the accreditation was for Orlando Stadium because he had been informed by Lieutenant-Colonel Johannes on 13 April that only the family and the president will come to the cemetery or graveside. Sub 7. It was then put to him that this was not true, as the video had shown other people arriving. He then responded that on the day of the funeral, when the convoy left the stadium, they were informed that the deputy president and the heads of state were part of the convoy. Sub 8. Nevertheless, he did not know how many vehicles made up the convoy. Sub 9. He conceded that most of the roads on the route to the cemetery had been closed that day. Sub 10. Consequently, it was impossible for any other vehicle to just join the convoy. Sub 11. He had seen the black Vito Mercedes vehicle, but did not see any visible vehicle permit, and even though they had the vehicle permit, I being he, would have stopped them. Sub 12. It was then put to him that the permit was clearly visible. In response, he said that he never saw it. Sub 13. It was further put to him that on the late Zinzi Mandela's version, Mr. Malema was part of the Mandela family. His response to this was, if Mr. Malema was part of the family, he would have driven with the family in the vehicle, in the car, or his vehicle would have made part of their convoy. Sub 14. It was then put to him that it had been part of their convoy. He denied this. Sub 15. He then conceded that on his version, the convoy was very important, but he had not mentioned the convoy in his statement to the police. His explanation was that he had given a short version of what had taken place because at that stage he was still in shock. Sub 16. Nevertheless, having seen the video a week later and having been given an opportunity to make a follow-up statement with the assistance of his union, Solidarite, and their attorneys, he still did not mention the convoy. Sub 17. He had only seen 3 people in the vehicle, but it was put to him that there were 4. Sub 18. His statement at paragraph 4 contained the words, I then explained to the people of the vehicle that they are not allowed to get inside the cemetery according to the instructions I received. Sub 19. He then tried to explain that the reference to the people of the vehicle meant the vehicle, but had to concede that his statement states what it states. Sub 20. His own statement further states that he had tried to contact the VOC to verify if he can allow them inside, which clearly did not refer to a vehicle. Sub 21. This was so despite the fact that on his own version they had accreditation which was around their necks. Additionally, his statement at paragraph 5 states, then General Zulu came and informed me that it was fine, they can get inside the cemetery. Sub 23. It was then put to him that this contradicted his version that they had never been given permission to enter the cemetery. Sub 24. Thereafter, as depicted in the video, the vehicle entered the premises without any hindrance. Sub 25. Significantly, then said that he could not speak on behalf of General Zulu. Sub 26. Despite the accused both having accreditation, he saw no need to apologize to them for preventing them from entering the cemetery. Sub 27. He had in fact established from General Sam Sitlebani that they were entitled to enter the cemetery. Sub 28. He then repeated that even if the vehicle had a visible permit, he would not have allowed it to enter the cemetery. Sub 29. He claimed to have seen a general practitioner but did not have any visible injuries, so he did not obtain a medical report. Sub 30. Constables Mashelo and Mokobe and General Zulu were with him and witnessed the incident. Sub 31. This handwritten statement was subsequently typed by his attorneys and such a copy was placed in the docket and accepted as Exhibit C. Sub 32. Solidarity had referred him to Herter and Spies, who in turn had referred him to AfriForum. AfriForum thereafter made it clear to the defense that he was not interested in any form of Ubuntu or regarding this matter. Sub 33. Second statement in the docket was dated 28 May 2019, which was 13 months after the incident. Sub 34. This statement gave more detail about the incident but not correct anything from his previous statement. Sub 35. Even though he had been told over the radio that the Deputy President and heads of state were allowed to enter the cemetery, at no stage did he have a list or know how many people this involved. Sub 36. In paragraph 5.4 of the subsequent statement, which was admitted as Exhibit D, he stated, these vehicles all had permits allocated to them for purposes of identifying them and to grant them access to the designated area. Sub 37. In paragraph 5 thereof, he further stated, the cars that are referred to in paragraph 2 of my first affidavit refer to the vehicle permits as mentioned above. Sub 38. In doing so once again, he had confused the accreditation of people with the accreditation of vehicles. Sub 39. Further, having had a year to correct his statement, he further stated paragraph 5.6. I recall that all vehicles without the said permits were to be diverted to an alternative designated area for non-permit carrying vehicles. Sub 40. He conceded that did not have the whole video of the incident concerning the arrival of all the vehicles and people. At that stage, the AfriForum representative made a comment in the court which interrupted the proceedings. Sub 41. He conceded eventually that he had watched the video to assist him with the compilation of his subsequent statement. Sub 42. The content of the statement in the docket by the late Zinzi Mandela was then put to him for his comments, but he had no comment in relation thereto, even though it was admitted as Exhibit E, eventually by consent. Sub 43. His further statement dated 18 November 2019 was admitted as Exhibit F. This dealt with vehicle accreditation at paragraph 5. He stated, I can confirm with certainty that the vehicle in which Mr. Malema arrived at the Memorial Park contained no identifying physical marks confirming that it had the right to enter the designated area. Sub 44. He then clarified that the identifying physical mark that he was looking for was a vehicle permit. Sub 45. He then yet again further clarified that the vehicle permit was on the left-hand side of the window, clearly visible, and that the vehicles that entered from the convoy had permits on the left-hand side in the window. Sub 46. He also repeated that he had not seen such a permit in the vehicle in which both accused had arrived. Sub 47. Nevertheless, he also repeated that even if the vehicle had such a permit, he would have stopped it. Sub 48. He also repeated that he had seen all the vehicles of the convoy except those driving the president and the deputy president had such a permit, and they were on white paper. Sub 49. He was shown the video of the cars arriving during the proceedings on 29 October 2020 and admitted that he could not identify the occupants of the vehicles. Sub 50. He also admitted that it was clear from the video that there was a fourth person in the vehicle carrying the accused. Sub 51. He conceded that the large man holding the umbrella with the EFF insignia held him back. Sub 52, eventually, having been confronted with a particular part of the video, he considered that there was something prominent on the dashboard of the vehicle. He thought it was a reflection of something by the window, but had not seen it and had not seen any accreditation. Sub 53, he conceded that none of the 12 uniformed people came to his assistance in what he perceived to be an attack against him. Sub 54. Similarly, they took no action when the vehicle entered the cemetery. Sub 55. When confronted with a photograph of the permit on the dashboard of the accused vehicle, he contended that when his back had been turned, somebody may have put the permit there. Sub 56. He then contended that when he went to the vehicle, the permit had not been visible. Sub 57. Eventually conceded this was all speculation on his part, and he could not say whether the permit was there or not. Sub 58. In this regard, specific reference is made to Exhibit 4.6, and more particularly the bottom photograph that reflects 04-14-2018, set 15:47:05, in which the permit is clearly visible on the dashboard of the accused vehicle. Sub 59. He had made the decision to not settle the matter by the process of Ubuntu and had utilized AfriForum to convey that message to the defense. Sub 60. He could not explain what had happened to the motorcycles that he contended would be at the back of the convoy. Sub 61. He also considered the priests had been part of the convoy. Sub 62. He had never established as a fact whether the accused vehicle had been part of the convoy or not. Sub 63. In fact, he had never established as a fact that the accused vehicle had not been entitled to enter the cemetery, despite the lapse of more than 2 years before he testified. Paragraph 28. The state then called the evidence of Mr. Dion Klingbeil. He testified as follows. Sub 1. He had been employed as the operational manager at Memorial Park Fourway since 2007 and was at work on Saturday, 14 August 2018. Sub 2. He explained where the video cameras were situated and where the control room was within their offices. Sub 3. He had downloaded the video extract from the system and provided it to Colonel Bronkhorst on a USB stick. Sub 4. He had also made a copy for himself that he kept away from his workplace. Sub 5. He had been guided by Colonel Bronkhorst as to what to put in before and after the incident when he downloaded the video footage. Sub 6. Colonel Bronkhorst's video footage was longer than the copy that he had retained for himself. Sub 7. After the docket had been lost, Colonel Nama had requested a copy of the video that he had retained for himself. Sub 8. The specific hard drive that he had saved the video onto was no longer available. Paragraph 29. Under cross-examination is referred to statements that were accepted as Exhibits G1, G2, and G3, respectively, that created the impression that there was only one copy ever made of the video. Never mentioned the meeting with Colonel Bronkhorst or giving him a copy of the video, but subsequently recorded that he had given the footage to both Colonels Bronkhorst and Sianejo and testified that, Sub 1, in none of the statements did he record that he had obtained a copy of the video for himself and taken it home. 2. He had copied it on a hard drive and on a CD and thus had a multiplicity of copies. Sub 3. He could not remember when he had given the footage to Colonel Sianejo, did not receive an official receipt for it. Sub 4. The footage was never placed into a sealed forensic bag. Sub 5. In his capacity as operations manager, he had not been given a list of specific registrations of vehicles that were allowed into the cemetery on that day. Sub 6. He could not say what type of authorization the vehicles had. He could see something white on the dashboard of the vehicle in Exhibit 4.6, but could not say whether it was an authorization or not. Paragraph 30. Colonel James Bronkhorst was the next state witness and testified as follows. Sub 1. On 14 April 2018, he was the acting section head for incident management and the protection and security services at the SAPS. Sub 2. He was notified of an incident that had transpired at the funeral and that Major General Zulu was on the scene and handling the situation. Sub 3. He had been in contact with Mr. Klingbeil to receive a copy of the video footage. Sub 4. He had given a copy of the footage to Colonel Venter. Excuse me. Sub 5. An internal inquiry had been held and his conclusion was that Colonel Venter had acted 100% correctly. Sub 6. Vehicles had to be accredited to be part of the convoy. Paragraph 31, under cross-examination, he conceded that, sub 1, he had made 2 statements in relation to this matter, neither of them mentioned the term convoy. Sub 2, was not certain whether the accused vehicle had been secured or accredited for the ceremony at Memorial Park. Sub 3, he had been led in chief in relation to his experience, but not in relation to the specific incident. Sub 4, on 14 April 2018, he was present at VOC and had not been given a list of dignitaries who were entitled to enter the burial ceremony. Sub 5, similarly, had not been given a list of accredited or authorized vehicles that were entitled to enter into the cemetery. Sub 6, in fact, he did not know whether any of those 2 lists ever existed. Sub 7, additionally, he was not aware of how the procession would take place from Orlando Stadium to Memorial Park for the burial. Sub 8, he did not know whether the route from the stadium to the cemetery was open to the public or not. Sub 9, he did not even know who would be speaking at the ceremony. Sub 10, he was unaware of the official program of the funeral service and had not seen it. Sub 11, the people who were described in the program as making tributes would be part of the so-called VIPs of the event. Sub 12, he had no comment to the statement by the daughter of the deceased that accused one was regarded as a family member of the deceased. Sub 13, accredited vehicles would have an identification sticker or a permit registered against the registration number. Sub 14, he was unaware where that remote security process took place in this instance. Sub 15, he could not dispute that the accused vehicle had been through such a process. Sub 16, if the vehicle had such a permit, it was allowed into the stadium and into the cemetery, provided it had been all the security measures that was part of the convoy. Sub 17, he could not dispute that the accused vehicle had been compliant. Sub 18, only General Zulu could explain on what basis she had authorized the accused vehicle to enter the cemetery. Sub 19, the vehicles with permits were allowed into the cemetery, those without were not. Sub 20, usually the hearse is at the back of the convoy, but in this instance he had seen on the video footage that the hearse was not right at the back. Sub 21, he had deposed to 2 statements that were admitted as exhibits H1 and H2, but had not dealt therein with which vehicles were allowed into the cemetery. Additionally, there was no mention of the term convoy in his statement. Sub 22, the complainant in this matter did not have the authority to stop the accused's vehicle if it was in the convoy and had a permit. Sub 23, the incident had taken place at approximately 15H44, but the first time that he had heard from the complainant was around 17H15. Sub 24, he still did not know whether the accused vehicle had undergone the screening exercises. Sub 25, it was an oversight from his side to have completed the internal inquiry without establishing whether the accused vehicle had undergone the screening exercise or not. Sub 26, he had obtained the video footage from Mr. Klingbeil for the internal investigation, not the criminal case. Sub 27, he could see something on the dashboard of the accused vehicle in the photograph thereof, as depicted in Exhibit 4.6. Sub 28, at no stage did he become aware of a request to VOC for permission to allow the accused vehicle in. Sub 29. Subsequent to the event, he was told that General Zulu was there and that she had taken control of the situation. Sub 30, he had not mentioned that he had given Colonel Venter a copy of the video in his statement. Sub 31, there was doubt because nobody could unequivocally state whether the accused vehicle was authorized to enter the cemetery or not. Sub 32, he had difficulty answering what should have happened if the car was not vetted and that entered because accreditation was given by General Zulu that the vehicle could go through. Sub 33, it remained the responsibility of the person that handled the incident. That is why General Zulu should be given the opportunity to come and testify about it. Paragraph 32, under re-examination he stated, Sub 1, there was not enough communication. Colonel Venter should have known what was the first car and the last car. Sub 2, the only person who can indicate on what basis the accused car was allowed to enter the cemetery would be General Zulu. Paragraph 33, the next state witness was Colonel Charles Mandlakapele Sianejo, who testified as follows. Sub 1, he had been the investigating officer in this matter prior to his retirement. Sub 2, he had obtained the video footage of the incident from Mr. Klingbeil. Sub 3, upon receipt, he had placed the video footage in a sealed forensic bag in front of Mr. Klingbeil. Sub 4, it had also been entered into the SAP 13. Sub 5, his statements were accepted as exhibits J1 to J4. Paragraph 34. Under cross-examination, he conceded that, sub 1, he was a colonel with 42 years of experience in SAPS. Sub 2, this was a high-profile matter. Sub 3, he had received 2 discs in this matter. Sub 4, he had not mentioned these 2 discs in his statement. Sub 5, he disagreed with Mr. Klingbeil insofar as he had testified that he had not sealed the disc in a forensic bag in front of him. Sub 6, this had also not been mentioned in his statement. Sub 7, it was inexcusable that he had failed to mention the booking in of the disc in SAP-13 in his statement. Sub 8, he had a poor recollection of what had transpired in this matter because it had occurred so long ago. His 4 statements were admitted as exhibits J1 to J4 respectively, and the SAPS-13 excuse me, SAPS-13 registers were admitted as exhibits J5 and J6. Paragraph 35. Under re-examination, he could not remember the details of what had happened in this matter and conceded that he did not have a safe in his office, merely a locker. Paragraph 36. The next state witness to testify was Warrant Officer Jacobus Nicolaas Vosloo-Smit. He testified as follows. Sub 1. He was a warrant officer at the Cyber Crime and Deep Web Investigations Detective Services Head Office of the SAPS. Sub 2. His 4 statements were admitted as exhibits K1 to K4 respectively. He had deposed to 4 statements because the investigating officer kept on coming back to him to add on to his initial statement, which he did. Sub 3. He had compiled a photo album which was admitted as exhibit 4 and comprised of 11 photographs. Sub 4, the photographs were taken of images in the video footage. Sub 5, he explained the procedure followed in doing so and the protocol concerning the sealing of exhibits in exhibit bags. Sub 6, due to a process of stick and paste, and as a result of human error, all of his statements had the same date and time. Paragraph 37, under cross-examination, he conceded that. Sub 1, the reception at his unit would not accept anything unless it was sealed in a forensic bag. Sub 2, the old bags are put into the new bags after analysis in order to keep the chain of custody intact. Sub 3, he had compiled an album that comprised of 23 images. Sub 4, mysteriously pages and photos of his original album had been removed, which was tantamount to manipulation but could not be explained by him. Paragraph 38, on that day, 10 March 2021, the state recorded that General Zulu was intended to be the next witness, but it supplied a sick note booking her off for surgery and recording that she had to undergo COVID tests in order to do so. 39. It was further stated that the state intended to call General Zulu, 2 constables, and a possible 4th state witness. 40. The presiding magistrate made it clear that if General Zulu was not available on the next occasion, the state should have other witnesses available in order to bring this matter to finality. The state was warned of a possible section 432, it should be 342A, inquiry in this regard.
So noted.
I'm just correcting it on the signed copy, Your I apologize. The next eyewitness called by the state was Staff Sergeant Gilbert Moleleki Mapisa. He testified that, sub 1, he had been employed by the military police for 33 years and was doing traffic duties on 14 April 2018 at about 1600 hours, wearing military camouflage and a reflective jacket at Four Ways Memorial Cemetery. Sub 2, after the convoy had entered into the cemetery, a Vito came traveling alone and he stopped it. He approached the driver but saw both the accused inside the vehicle, so he allowed it to enter, gave them the direction, and told them to go straight. Sub 3, the vehicle was traveling alone, had no escort, and there were no blue lights. Sub 4, he then heard a noise, saw people pushing each other, and proceeded to them. Sub 5, he then came between them. There was an issue about this translation, but it was subsequently resolved. Sub 6, accused 2 was furious and asked why they were not being allowed to enter. He then calmed accused 2 down and told him to get into the vehicle. The vehicle then entered with both of the accused in it. Sub 7, he did so because he recognized that there were VIPs in the vehicle. Paragraph 42. The state then attempted to lead him on his statement with a view to explaining the different versions, but after an objection by the defense counsel was prevented from doing so because it was tantamount to cross-examining their own witness without declaring him hostile. Paragraph 43. Under cross-examination, he conceded that, sub 1, By virtue of his 33 years' experience, he had worked at many state funerals and knew the protocol. Sub 2, this was the first time that he had met Colonel Venter. Sub 3, since 14 April 2018, he had not seen Colonel Venter again. Sub 4, there had been no personal interaction between Colonel Venter and him, yet he claimed to have remembered his name, which was challenged. Sub 5, in his statement, he had not mentioned the name of Colonel Venter. Sub 6, he still maintained that he remembered Colonel Venter's name, even though he had only made a statement more than a year later, on 2 December 2019. Sub 7, he could not remember the date of this incident. It was given to him by the investigating officer. Sub 8, in his view, his oral testimony and the written statement were both true and had both been given under oath. Sub 9, the funeral of Mrs. Winnie Madikizela-Mandela on 14 April 2018 was an auspicious occasion and knew that there were lots of dignitaries, VIPs and members of government that would be there. He had, however, not mentioned this in his statement. Sub 10, he had not been shown the program for the day, Exhibit A, but had watched the proceedings on television. Sub 11, his statement was admitted as Exhibit L and expressly recorded in paragraph 2 that, quote, on Saturday, 18/04/14 at about approximately 1600 hours, was posted there at the Fourways Memorial Park to control traffic and parking duties. I confirm that the vehicles that were having escort were directed straight to the VIP parking, including the Black Vito, which was transporting the EFF members. Sub 12, he in fact confirmed that this was both correct and true. Sub 13, he had not mentioned stopping the vehicle in his statement. Sub 14, according to him, they had the right to enter because he had seen the VIPs in the vehicle. Sub 15, despite the above detailed express recordal in his written statement under oath, he was of the view that the Black Vito vehicle was not part of the convoy. Sub 16, nevertheless, he had confirmed his statement and never indicated that it contained a mistake. It was further put to him that these two versions are irreconcilable. Sub 17, despite having claimed that he had stopped the vehicle, he could not remember how many people had been in the vehicle. Sub 18, he had not looked for a permit because, having recognized that the vehicle had VIPs in it, he was of the view that it was entitled to enter the cemetery. Sub 19, in fact, he had been instructed that the VIPs must enter. Sub 20, thus directed them straight to the main gate of the cemetery because all the vehicles were entering through the main gate at the cemetery. Sub 21, he allowed the vehicle to enter because it had VIPs. If that vehicle did not have VIPs, he would not have allowed it to go through. Sub 22, he had no doubt that the vehicle was entitled to enter because it had VIPs and had to enter. Sub 23, accused 2 had questioned why they had been refused entry when they had credentials and were entitled to enter. Sub 24, he had calmed accused 2 down and told him to get into the vehicle so that they could enter the cemetery. Sub 25, he had sent the vehicle directly to the main gate because it was a VIP vehicle. If it was not, then he would have sent it to the left side. Sub 26, he agreed that both of the accused had believed that they were entitled to enter the cemetery for the burial ceremony. Under re-examination, confirmed that he had allowed the vehicle into the cemetery because he had seen 2 VIP gentlemen in it. So by pause to mention, in response to everything that's been quoted thus far, there are footnotes that refer to the transcript and the particular date, page, and line numbers in order to validate what's stated on behalf of the witnesses. There's then a subheading, Your Worship, further state witnesses. 45. Thereafter, the state released Sergeant Makobi as a state witness and made her available to the defense. 46. Subsequent to that, the state applied for another postponement to secure General Zulu as a state witness because she was yet again sick. Similarly, on 7 April 2022, she had sent a sick note to the state in which it was claimed that she had been examined on 5 April 2022 and was unfit to work from 6 to 8 April 2022. 47. Thereafter, the state applied for a postponement of the matter, which was opposed. 48. The state was then warned by the presiding magistrate that the provisions of Section 342 capital A would be applicable with regards to any further delays. The matter was then remanded to 6 May 2022. 49. On 6 May 2022, the state recorded that it had consulted with General Zulu the previous day and expected her to be in attendance. but had yet again received a sick note claiming that General Zulu had been examined on 5 May 2022 and booked off from 4 to 8 May 2022. In the circumstances, the state applied for a further postponement of this matter. 50. This application was opposed, and the presiding magistrate refused it. The state was then compelled to close its case and agreed times within which heads of argument would be filed concerning this application in terms of Section 174 of the Criminal Procedure Act. Subheading discussion. 51. Whilst the testimony of the state witnesses was improbable, riddled with contradictions and less than acceptable, a distinction must be drawn between the evidence concerning the chain of custody and the admissibility of the real exhibits on the one hand and the eyewitness testimony on the other hand. 52. Regarding the real evidence and chain of custody of evidence, the video footage was admitted and viewed in court by consent. There can be no doubt that Exhibit 4 was manipulated and does not contain all of the photographs that were created by and intended by Warrant Officer Smith to be in it. 53. In relation to the eyewitness testimony, and due regard being had to the case law cited above, as well as the evidence led by the state in this matter, it is respectfully submitted that there is no evidence that the accused committed the offence referred to in the charge, or any offence of which they may be convicted on the charge, so this court is entitled to discharge the accused and return a verdict of not guilty. 54. This is particularly so if regard is had to the material contradictions in the testimony of the complainant, Colonel Venter, as compared to his own written statements, and further to the testimony and statements of the other eyewitness, Staff Sergeant Mapisa. 55. Most significantly in this regard, Colonel Venter's version and his basis for refusing the accused to enter the cemetery in their vehicle changed from initially being that, sub 1, nobody other than the immediate family and the president were allowed to enter in vehicles, to sub 2, only accredited vehicles with permits could enter, to sub 3, the accused vehicle had not been part of the convoy, to sub 4, the accused vehicle was not accompanied by an escort, to sub 5, even if the accused vehicle had such a permit, he would not have allowed it in, to sub 6, he had radioed VOC to obtain permission for the accused vehicle to be allowed in, to sub 7, General Zulu had not permitted the accused vehicle to enter the cemetery, to sub 8, General Zulu had permitted the accused vehicle to enter the cemetery, to sub 9, only General Zulu could explain why she had allowed the accused vehicle to enter the cemetery. 56. In addition, the failure by General Zulu to testify cannot be ignored. It is common cause that after the confrontation between the complainant and the accused, she in her capacity as the superior officer granted the accused permission to enter the cemetery in their vehicle, and no action was taken against them for having done so. 57. In the circumstances, it is clear that they were entitled to enter the cemetery, and the complainant was not entitled to prevent them from doing so. 58. Additionally, and as detailed above, Staff Sergeant Mapisa had expressly stated, paragraph 2 of Exhibit L, quote, that the vehicles that were being escorted were directed straight to the VIP parking, including the Black Vito, which was transporting the accused. The word including is underlined for emphasis. Paragraph 59. Regard being had to Exhibit 1, the VIP parking was only accessible via the main gate that was manned by the complainant. It is thus clear that he was not entitled to deny access to the vehicle transporting the accused. 60. These submissions are further amplified and borne out by the official program, Exhibit A, which indicated that accused 1 was scheduled to deliver tribute to the late Winnie Madikizela-Mandela at the burial ceremony. 61. Over and above the official program, Exhibit A, regard must be had to the statement by Ambassador Zinzi Mandela, Exhibit E, the deceased daughter of the late Winnie Madikizela-Mandela, in which he states inter alia that, quote, I was shocked to learn recently that Mr. Julius Malema was on the verge of being criminally charged for being involved in a scuffle with Lieutenant-Colonel Venter of the South African Police Service at the gate of the Fourway Cemetery on the date of my mother's funeral. I was even more appalled on the day in question when I was told that some members of the South African security forces who were on official duty at my mother's funeral had attempted to prevent Mr. Lema from entering the cemetery to pay his last respects to my mother, who literally raised him and regarded him as her own biological child and son. This is a fact that is or should have been known to any person who regards themselves as South African. In any event, any security briefing preceding the funeral ought to have been identified as the most obvious members of the Mandela family, including our extended family. It was no coincidence that Mr. Malema was one of the key speakers at my mother's funeral. Despite some political resistance, the Mandela family had insisted that Mr. Malema be part of the program. Without him, the funeral would have been incomplete or carried out against the wishes of the person being buried. Again, any member of the security forces ought to have been briefed about or be in possession of the program. To prevent Mr. Malema from entering the cemetery would have created the most serious violation of the specific wishes of the Mandela family. To prevent a son from burying his own mother in the name of the law is an unthinkable act of provocation. There was in any event no justification for attempting to block Mr. Malema from entering the graveyard. Paragraph 62. According to the distinguished author C.R. Snyman in the textbook entitled Criminal Law 6th edition at pages 98 to 99, I quote, one must always first establish whether an act which accords with the definitional elements is not perhaps justified because the legal convictions of society deem the act committed in those particular circumstances in fact to be lawful. The act is then not unlawful. The grounds of justification must be seen as practical aids in the determination of unlawfulness. They merely represent the situations which are most often encountered in practice, which have therefore come to be known as easily recognizable grounds for the exclusion of unlawfulness. They do not cover the whole field of the subject of this discussion, namely the demarcation of lawful and unlawful conduct. The following is an imaginary example of a situation where X's act, which at first sight seems to break the law, is in fact not unlawful, despite the fact that it does not fall under one of the recognized grounds of justification, which will be discussed below. X is the owner of an attractive guest house next to a tarred road. The success of a business depends upon the traveling public being able to reach a property via the tarred road. Over the years, the provincial authorities responsible for keeping the road in good repair neglect their duties, with the result that the road becomes near impossible. X's complaints and asks authorities to repair the road, but the request falls on deaf ears. At last, she and people in her employ break the existing pieces of tar, remove them, and retar the impossible piece of road. As a result of her actions, she is charged with the crime of malicious injury to property, in that she had destroyed parts of the road belonging to the provincial authority. She can then successfully rely on a plea that her conduct was lawful, it accorded with the community's perception of justice, or the legal convictions of the community. It caused more benefit to society than any conceivable harm and was therefore socially adequate. 63. In any event, the objective facts speak for themselves. The accused were permitted to enter in their vehicle without hindrance after the intervention by General Zulu, and in accordance with the established protocol of the day, their vehicle having been part of the convoy and bearing the requisite permit to do so. 64. Consequently, both accused should be discharged in terms of the provisions of Section 174 of the Criminal Procedure Act 51 of 1977. Then it's signed by myself in this form, Your Worship, dated 12th of May 2022. I beg leave to hand up the signed, corrected version, if I may, Your Worship.
You may do so. Thank you.
Thank you, Your Worship. I have no further ado, Your Worship.
Thank you. Court received then the heads of arguments, and it will be marked as Exhibit M.
As Your Worship.
Thank you, Ms. Hart.
In the Magistrate Court for the District of Johannesburg North, held at Randburg, in the matter between the State and Julius Malema, accused number 1, Mbuyiseni Ndlozi, accused number 2. State's heads of argument on application for a discharge in terms of Section 174 of the Criminal Procedure Act 51 of 1977. Introduction. The two accused before this honourable court has been charged with assault as alleged in the charge sheet. The two accused pleaded not guilty and elected to disclose their defence in terms of Section 115 of the Criminal Procedure Act 51 of 1977. Sorry, Your Worship.
Yes.
The basis of the not guilty plea is that one of justification. Both accused believed they went up to enter the cemetery for the burial ceremony, and that the obstruction of them was illegal and unjustified. In in the circumstances, they lacked mens rea because they believed, at the very least, that they were entitled to enter the cemetery for the burial. I recall that there is a political agenda here. This is an assault common case. They both reached out to the complainant by process of Ubuntu that was rejected by a free forum. So this turns out to be political, while that there is a political agenda between AfriForum and the EFF that is being played out in this court. Of the closure of the case for the state, both accused lodged an application for discharge in terms of the provision of Section 174 of Act 51 of 1977, the offence of assault definition. Assault consists of unlawfully and intentionally, A, applying force directly or indirectly to the person of another, or B, inspiring a belief in another person that force is immediately to be applied to him or her. Elements of the offence. Number one, application of force, or the inspiring of a belief that force is to be applied. Number two, unlawfulness. Number three, intention. The application before court in terms of Section 174 of the Criminal Procedure Act 51 of 1977. Section 174 states that if at the close of the case for the prosecution, at any trial, the court is of the opinion that there are no evidence that the accused committed the offence referred to in the charge or any offence of which he may be convicted on the charge, it may return a verdict of not guilty. It is my humble submission that there are three words that are of utmost importance when considering this application, namely opinion, no evidence, may. In determining the interpretation of these words, it is of utmost importance to ascertain what the case authority highlighted as being interpretation thereof. In S versus Farco and others, 2004, 3 ALL, SA 501, SK at 504, I to J. The words no evidence have on numerous occasions been interpreted to mean no evidence upon which a reasonable man acting carefully may convict. Circumstantial evidence consists of facts from which a fact in dispute may be inferred. It has been held that where the uncontradicted evidence of the state is circumstantial and more than one inference may be drawn, a discharge should be refused. It is a state submission that the evidence before court deals with direct evidence and thus the issue regarding circumstantial evidence is moot. In S versus Swartz 2001, 1 SACR 334, WLD 335E2F. Credibility in an application for discharge under Section 174 is one of the features to which the court can have regard, but it plays only a limited role. It is one of the factors to which the court have regard in the assessment of the quality of the evidence. The contextual scene, the evidence given in the case that conflicts with other evidence, which renders such evidence irreconcilable and unacceptable, all towards determining the quality of the evidence. It is the state submission that not only having direct evidence of the complainant Colonel Johannes Venter regarding the assault, this oral testimony is corroborated by the following evidence before court. 1, video footage as real evidence. Number 2, the evidence of Mololeko Gilbert Mapisa. And number 3, the version placed on record by the accused's legal representative never placed the assault in dispute. I refer this honorable court to Bennett versus the Minister of Police, 1983 ALL SA 817C, 1993 SA 24C, where the court of course stated that lack of knowledge of wrongfulness is not a defense. Further on the aspect of wrongfulness, the court further stated that every infringement of the bodily integrity of another is prima facie unlawful. In Groenewald versus Groenewald, 1998 2 AL SA 335A, 1998 2 SA 1106, SCA, pages 1111 and 1112, an allegation of assault implies such an intention animus ignorandi. The plea explanation raises a defense of justification. Grounds of justification may be described as circumstances which occur typically or regularly in practice and which indicate conclusively that interference with a person's legally protected interest is reasonable and therefore lawful. In the article of G.P. Fletcher, Rethinking Criminal Law 2000, 759, see also L. Austin Philosophical Papers 1970, 123 to 4, and also H.L.A. Hard Punishment and Responsibility 1968, 13 to 4. George Fletcher explains by contrasting a justification with an excuse. The notion of justification and excuse have by now become familiar figures in our structural analysis of criminal liability. Claims of justification concede that the definition of the offence is satisfied, but challenges whether the act is wrongful. Claims of an excuse concede that the act is wrongful, but seek to avoid the attribution of the act of the actor. A justification speaks to the rightness of the act, an excuse to whether the act is accountable for a concededly wrongful act. The owners of
Well, we're coming out of that process. The state reading their response into record in that case against Julius Malema and Mbuyiseni Ndlozi. We'll take you back there when final summations are being made. But let's take you now live to the Pretoria High Court. The Senzo Meyiwa murder trial still continues.
For the beginner, I can be able to start. Your Lordship, I'm standing as I'm standing here because of the new discovery insofar as this matter is concerned, being that the continuation of this witness today, if my learned colleague has to continue, it will be a futile exercise. Why? It's because it has been discovered that my client, including even accused number 5, they made a first appearance in Boksburg on the 20. I was thinking I'm right to say the 26th of October 2020, but my client corrected me to say it was the 27th of October 2020. It was when they appeared in Boksburg court at 10 o'clock. The heinous discovery is that Your Lordship, that they've appeared